During the COVID-19 pandemic, there, of course, have been numerous legal proceedings, but most of those have been at the college level. And primarily, those have been focused on professionals who have not complied with public health measures or who are alleged to have been making misleading statements about the utility of public health measures. After 2 years of the pandemic, the legal challenges in the context of professional regulation are now reaching the courts. We're sure to see more of these. And challenges right now are primarily being brought by professionals who are opposed to the mandatory public health measures.
There's less case law that speaks to, what does procedural fairness look like in the context of a competency assessment that precedes a decision or a formal hearing, potentially, in terms of that registration decision. And the court's decision in a case called Sandu and College of Physicians and Surgeons of Alberta speaks to this issue. The Court of Queen's Bench reviewed the decision of the assistant registrar and found that the assessment process was fair and the decision not to grant registration was reasonable. The court held that although there was no manual regarding the process, there was information disclosed to Dr. Sandu that established what the expectations were. And in fact, there was a letter of understanding that he received regarding what the assessment would entail, and that was sufficient to meet the requirements of procedural fairness in the circumstances. And so the court held that there was a duty of fairness owed to Dr. Sandu, but the college had discharged the duty owed to him. And in coming to that conclusion, the court really emphasized the public protection mandate of the college and confirmed also that significant deference has to be given to regulators in determining how they meet that public protection mandate.
Governments and the public, of course, expect regulators to have a transparent disciplinary process. We all hear it: transparency, transparency, transparency. And a key tool for regulators is a publication of information on their websites. So what do we learn from these cases? I mean, first of all, it's a dramatic number of cases challenging the publication of discipline information on college website. Tips for regulators as we reflect on these cases: everyone should be reviewing their governing legislation and privacy legislation to ensure that your publication practices are consistent with legislation. You need to ensure that you have up-to-date, clear, written, defensible publication policies. And if legislation or policy requires that discretion be exercised, as in the BC Court of Appeal case, ensure that discretion is exercised.